another 1 minute? Okay. लाइव हो गया है.
So, sir has joined. Good evening, everybody.
Good evening.
Good evening, sir.
Good evening.
So today we all have gathered here for our third lecture on the SCAORA lecture series for the AOR aspirants. Today we have with us Senior Advocate Anupam Lal Das, sir, who will deliver a lecture on drafting and share his valuable insights. This lecture is also being live broadcasted on YouTube. So anybody who has questions can put in the question in the chat box and it will be taken up at the end of the session. It will be also recorded for later viewing. Now, I would request our Vice President SCAORA, Sir Amit Sharma, sir, to give a brief introduction of sir.
Very good afternoon, all of you. Before I proceed to introduce our distinguished speaker for today's lecture on drafting, let me share with you that drafting, according to me, is one of the most important areas in the practice of law. Drafting actually reflects your in-depth knowledge of law, your communication skills, your application of law. We must remember that a good and careful drafting can actually make or break your case at any given point in time. See, drafting, according to me, should be as simple, as precise as it can be. Now, having said that, let me now introduce Mr. Anupam Lal Das, Senior Advocate, who has graciously agreed to give a guest lecture on drafting to all of us. Mr. Das, being a first-generation lawyer, before being designated as a senior advocate by the Honorable Supreme Court of India in the year 2019, has put in 18 years as an advocate on record. He has conducted first criminal case under Section 66 of Information Technology Act. Besides that, he's done many pro bono cases like rehabilitation of Bhopal gas tragedy victims, implementation of statutes regarding removal of manual scavenging, etc. Mr. Das has written many articles on various branches of law. Mr. Das has been actively practicing in areas of constitutional law, criminal law, civil law, insolvency and bankruptcy code, service matters, arbitrations, PIs, etc., etc., etc. The list is endless. Besides, Mr. Das is also a passionate cricket player and has played All India Lawyers Cricket Tournament, and he also sponsors a team in the annual Supreme Court Bar Association Cricket Tournament. With this, I would now request Mr. Anupam Lal Das to take over.
Thank you so much, Amit, for your take on the issue of drafting. And I completely agree with you that drafting is perhaps one of the most important facets of advocacy. A good draft means that half the battle is won. So just taking it forward from there, I am now, let's get on with my lecture. So first of all, I mean, take it that I'm addressing a gathering of professionals and not just college students. So I may not be able to tell you much because most of you would already know the importance of drafting. But having said that, I would like to base my lecture on the premise that most of you are to attempt a paper of drafting and you have only 3 hours to attempt about 5 questions, and there could be sub questions in those 5 questions. So it is the first thing is that you must time yourself. If you have to answer 5 questions, then I will give you an examiner's perspective. So while examining the paper, we often notice that the first and the second answers are brilliantly written. Third obviously suffers. Fourth and fifth, either somebody is not able to attempt the fifth question, and fourth question is also very poorly attempted. So the first thing is that you have to time yourself. So the first answer may take you 5-10 minutes extra, which is very human. You want to give your best in your first answer. But don't get carried away. Your first answer, suppose you have 40 minutes per answer, then your first answer should not take more than 45 minutes. That's one. Two, again, an examiner's perspective. Handwriting is something which is very important. Now, everyone, obviously all of us understand that because of paucity of time, you may not be able to write in a very sort of nice handwriting, but then at least your handwriting should be legible to the person who's evaluating you. Because if I am not able to sort of make out what you've written, so it's a big put off for any examiner. If an examiner has to examine, say, 300 answer sheets, and if he's struggling to read those answers, then it's a big put off, and you straight away lose about 15-20% of the marks which you may have got had your handwriting been slightly better. And fourth, please understand that drafting is something where you want to convey to the examiner. I'm just from the AOR examination perspective. Your language must be simple. You should write small sentences. You have to be lucid, and we should be able to make out what you are writing. So therefore, please concentrate. And if you make grammatical errors, so normally an examiner, while examining the answer sheet, those grammatical errors are bound to come to the notice of the examiner, and if you make too many grammatical errors, then you are bound to lose marks. Now, fifth, and this is just a continuation of what I've already said, the need to complete the answer sheet. See, if you write 4 answers which are absolutely brilliant and you're not able to attempt the 5th one, then you are being evaluated on 80 marks. And no matter what you've written, out of 80, you will not get more than 50-55 marks, even if you do extremely well. So one can still understand that for your 5th answer, you just sort of give the format, because normally the marking pattern is based on 2 aspects. One is the format of the question, the answer that you write, and 2 is the content. Now, format and content, they don't carry equal mark. The content is normally more than that. Again, depends on the pattern that the examiner chooses. So both things are very important. Now, this time, I believe about 172 of you have attempted to write on a computer. So it's a computer-based evaluation for some of you. So all the best to people who are writing on computer, because then I'm sure that they would be pretty good in typing. So for people who are attempting on a computer, you have to be very alert as to how you attempt your answer. Now, We all know the importance of this paper. As an advocate on record, most of you would be joining this great institution called the Advocate on Record in the Supreme Court. And drafting is something which will really take you forward. So all the best, all of you. Now, I just want to tell you, because normally people want to know as to how they attempt an answer. For example, you get a civil SLP. So what do you write in the civil SLP? Do you have to draft out the entire format? So you have to obviously look at what Form 28 is in the Supreme Court rules. So formats and all of you would get. So now people often ask, do we have to draft out the certificate, the affidavits, the cover page, etc., etc. So to which my only hint to all of you would be that if you are not asked to draft out a certificate or an affidavit, etc., etc., then you just have to show to the examiner that you know that this is a part of a civil SLP. Like for instance, if you look at the last year's paper, the questions were very, very specific, and you were clearly asked to draft 1, 2, 3, 4, and not 5, 6, 7, 8. So, I mean, if there is clarity in the paper, then you need not worry at all. Now, if you are running out of time and you've already drafted one affidavit and one of the answers, then you could just indicate to the examiner that for affidavit, please refer to the format in answer number 3. So this is also the examiner must know that you know, and you would definitely get marks. Now, the most important question which all of you would want to ask me, though this time I am not the paper setter, but what can you expect in the exam? So first of all of you know that Supreme Court is now also a court of appeal for many statutes. There is a direct appeal to the Supreme Court. So there are about 26, 27 acts which have a direct appeal to the Supreme Court. The most common of them, which you may expect, last time there was a question on election appeal. So at least for these major acts, you must know the provision under which an appeal lies to the Supreme Court. For example, an election appeal, what is the provision? You must know the Representation of the People Act. For example, NCLAT, under the IBC, there's a statutory appeal. You must know the provision. So unless you've read IBC, you may not know. Then National Commission. Then you have the Armed Forces Tribunal. CAT, of course, is through the High Court. So at least these major statutes, you must look up and you must know which are the provisions under which an appeal lies. And you must also know the format of the appeal. It is very, very important to know the format of the appeal. Then, of course, civil SLP everybody would do. Criminal SLP everybody would do. And you are expected to know if you are attempting this paper. Apart from this, transfer petitions. Now, one is a typical matrimonial transfer. The other could be a criminal transfer. So the yardstick for a matrimonial transfer is completely different from that of a criminal transfer. Then the concept that justice should not be done, only be done, but should be seen to be done. So this is applied in a criminal transfer. Then, apart from this, of course, you have to know this is a PIL season. For everything, there's a PIL. So even for arrest, detention, etc., people who are unconnected are also filing PILs. So you must be aware of the format of a PIL, when a PIL is filed, when a PIL is not filed, whether there could be a PIL for a service matter or not. So all these things you must look up, because there are at times strict questions for PILs in a service matter, not maintainable, RKGen, etc. principles. Now you must know the format of a writ petition. What are the kinds of writ petitions? When are they invoked? So 5 writ petitions, etc. You must know. And then, of course, the difference between a civil SLP and a criminal SLP. How the format of a civil SLP and a criminal SLP. Now, another thing, for instance, an arbitration petition for appointment of an arbitrator directly by the Supreme Court. When does it lie? And finally, these days one is also looking at suits, direct suits in the Supreme Court. So it is very, very important for you to know when is a suit filed, what are the kinds of disputes between center state, state versus state, etc. when a suit is filed before the Supreme Court. And a suit format you must know, and you could expect a suit as well. So this is broadly what you have to study for your drafting paper. But again, at the cost of repetition, I must tell you 2 things which are very, very important. Number 1, please time yourself. Number 2, please complete your paper. And number 3, please, your handwriting should be legible. And number 4, when you answer, suppose answer number 1, between answer number 1 and answer number 2, there should be a distinct gap, so that the examiner does not, inadvertently miss out on your answer number 2. So either use a fresh sheet to start your answer number 2, or there should be a clear gap between answer number 1 and answer number 2. So now I think I've broadly covered everything, and I can take questions.
Thank you, sir, for such a valuable insight, especially on the way to categorize the answers and the timing and the spacing. So there are not many questions which have been asked. I think you've already delivered quite an insight on it. However, there is one question which is there regarding what is the criteria of examination marks to be given, and how the marking is done. So if you can share an insight on that as well.
See, there are 2 things. One is the format of an answer, which is important, but what is equally important is the content. But what I would, recommend to all of you is that don't, for example, questions of law. 2 questions of law is good enough. Don't be repetitive. Grounds, 3 to 4 grounds are good enough. If you make out 10 grounds, then obviously you'll be repeating your grounds, number 1. And number 2, you'll definitely run short of time. So don't think that if you've drafted especially in your first answer, 8 questions of law and 12 grounds, then you're going to get, 20 on 20. So just be very, very sort of clinical in your approach.
There's another very important question by Sir Amit sir, which has been asked, that whether we have to put citations in the case laws as well or not, if we are referring to any citation.
No, see, for example, it's a very important question. For example, if you are asked something which comes out of quashing, right? If you just mention Bhajan Lal, that's the Bible on all quashing laws, and then we've had many. So if you say Bhajan Lal, then the examiner would know that you know the concept of quashing and the 7 tests laid down in Bhajan Lal. So, but please do not manufacture, citations, case laws, because you would definitely get caught, and then you lose. For example, curative. It's very important. Curative. Rupahura. I mean, the examiner would expect you to write. Okay, so if you know, then definitely it's an added advantage.
So there's another question for discussing on the format of the appeal. If you can just share a brief introduction on that as well.
See, for example, an NCLAT appeal, right? If you just, in fact, you would find many of these formats in the learned Attorney General's book. So if you can just, if SCAORA can help out the students who are taking the exam, and otherwise the main book is the Supreme Court handbook. So that handbook is very, very helpful. Please get hold of that handbook. And otherwise, I'm sure Mr. Amit Sharma can make available in the SCAORA office for people who are looking for appeals. At least, formats of these 4 or 5 statutes where one can, because obviously there are 26, 27 statutes. So one may not, just these 4 or 5 important statutes where there's an appeal to the Supreme Court.
So there's another very important question which is there that in a 40 marks question, what is to be given more priority in the answer?
No, number one, there'll not be a 40-mark question. So normally you ask 5 questions. So it's divided into 20. So last time, for instance, if I remember correctly, we had 6 mark for the format and 14 for the content. So, but then it differs. But there is always more mark to the content and than the format.
Very well, sir. So I think these are the relevant questions. I think there's no more question which is there. And thank you so much, sir. And I would now request Vishal, sir, to give a vote of thanks. And Secretary, sir, Mr. Nikhil Jain. Over to you, Nikhil, sir. Vishal, sir, if you can.
Thank you. Thank you, Meenakshi. It is indeed an honor to present the vote of thanks here. I'm thankful to Anupam sir for having kindly agreed to deliver this lecture. I'm sure all the aspirants who are going to sit for this exam this lecture will be really helpful. Thank you, sir. Thank you very much. Now, the skill of drafting, as already said by Amit sir, is a very important tool for lawyers which can break or make a case. I fully agree with this. With this, I also thank Amit Sharma sir, our Vice President, Nikhil Jain sir, our Honorary Secretary, Meenakshi, Astha, and all the EC members without whom this lecture would not have been possible. Thank you very much. At the end, I would also convey my regards and best wishes to all the aspirants. I'm sure they'll do well. Best wishes to all of them. Thank you very much.
Thank you. Thank you.
Thank you, sir.